Law firm, and this is day 20 of our 30 days of appellate tips. We're heading into the home stretch here with only 10 days left. Today's tip has to do with defect letters. So a lot of times I get calls from trial attorneys who are working on an appeal and they're in a panic because they received a defect letter. Or other times I have people call me and say, I looked up so-and-so's case history and they had so many defect letters. Why can't they get anything done right? Well, defect letters should be treated as a friend. It is very appreciated that the Court of Appeals sends so many defect letters for minor mistakes. I mean, normally some courts, some places around the country and in the state, if you have something that you've done wrong, they'll just try to dismiss your case. And so appellate attorneys do look at defect letters as their friend because it gives you an opportunity to correct whatever the mistake may be. And sometimes they send defect letters by mistake, and there's actually an error on the part of the Court of Appeals, which can be corrected with a phone call. But be grateful that you received a defect letter. So there's very few mistakes that cannot be corrected at the Court of Appeals. Two of which are if you do not timely file your claim of appeal, that's the end of that question. Your case will be dismissed. And maybe if it's not too late at that point, you can file a delayed application for leave to appeal. And the other thing that can't be corrected is if you file an appeal and the Court of Appeals does not have jurisdiction. So you won't be able to correct those defects, but everything else can be corrected, and the Court of Appeals is very gracious about allowing appellate attorneys to correct those defects. Good luck.